Howdy, Facebook Live. Sean Yesner here with Yesner Law and the Crushing Debt podcast. And so I'm going to do another couple of recordings. I need a recording for next week, and I need an episode for the week after that. So I'm going to do two podcast recordings. And I thought while I did, I'd give you all a behind the scenes look of how I record. So you'll be able to watch this here on Facebook Live. And this episode I'm about to record here will be going live this coming Thursday, the 13th. I'll stop and then I'll record another one that'll go live the week after that, the 20th. So I'll say it probably again in the video, but even though I'm recording this today on Facebook Live, this episode will go live a couple days before my birthday. So nothing necessarily special for my birthday, but I will probably mention it on the show. So, again, if you guys have questions, let me know once I'm done recording the show. Would love to answer your questions. If you have any, just go ahead and post them and I'll watch them here. So with that, I'm going to get started on a recording for the Crushing Debt podcast. On this week's episode of the Crushing Debt podcast, why people file for bankruptcy. So hello and welcome back to another episode of the Crushing Debt podcast. My name is Sean Yesner with Yesner Law. I'm also a new author, having written a book also entitled Crushing Debt, 9 Strategies to Eliminate the Financial Bullies in Your Life. And so one thing along with the book, one thing along with the podcast, I've done a lot of episodes on bankruptcy. And so one thought occurred to me is to do an episode about why my clients file for bankruptcy or why my clients feel they need to file for bankruptcy. Now, a lot of the topics that I'm going to cover in today's episode are in the book. And so I would encourage you all to go to Amazon, grab a copy of the book. A lot of the topics that I'm going to talk about are in there. But basically there's all kinds of different reasons. I remember back in 2008, 9, and 10, when we were going through the crash and people kept saying, we need to stop foreclosures. We need to stop foreclosures. And my comment always was, well, we can't really stop foreclosures unless we stop the things that lead to foreclosure. And I think bankruptcy is very much the same way. A lot of the things that lead to a foreclosure will also lead to a bankruptcy. So what are some of those topics? Well, one of them is divorce, a topic that I covered in last week's episode. A lot of times divorce will lead to a bankruptcy. Now, here's the interesting thing. Divorce attorneys are very good referrals for me. I don't do divorce. And so when I get a client who wants to file a divorce, I need to refer that out somewhere. But the reason that a divorce attorney is a really, really good referral source for me is that they're bound by conflicts of interest. So they can't do one thing that would harm another client. And so a divorce attorney, in a lot of cases, unless it's like a collaborative divorce or something, but other than a collaborative divorce where the divorce attorney is simply drawing up documents, in a contested divorce situation, the divorce attorney cannot represent both the husband and the wife, but I can. I don't have those same types of conflicts of interest that a divorce attorney would have. So divorce attorneys are great referrals for me because I can represent both the husband and the wife if the divorce is amicable enough, and I can file the bankruptcy. I can eliminate the debts of both spouses. And then once the divorce is final, they literally start with a fresh slate, not only from each other, but also from all of their debts. But divorce is definitely one of the reasons that a lot of my clients have to file for bankruptcy. Now that if they can't stand being in the same room together, then obviously I would only represent one or the other. And last week's episode was a good conversation about how the debts of one spouse may not be eliminated by the bankruptcy court, or the fact that if it's a joint debt and only one spouse files, the other spouse would still potentially be liable for all of those debts in a bankruptcy scenario. So divorces are definitely situations where we may want to consider bankruptcy if one of the spouses hasn't been working and isn't working and has joint debt and feels like they may be hurt by the divorce itself in terms of being able to repay the debt. There's no conflict of interest there for me to represent the husband and the wife, get them their divorce, get them their fresh start, and then they go on, they finish the divorce, and then they truly start with a clean break. So divorce is one of the reasons why I have clients come to me and file bankruptcy. Another one that begins with a D is death. So a lot of reasons that people file bankruptcy is someone has passed away. Now, what I mean is someone has passed away and left a surviving spouse. I think one of the biggest misconceptions that I get in a bankruptcy scenario is, if my husband dies, am I going to be responsible for his debt? If my mom dies, am I going to be responsible for her debt? If my child dies, my adult child dies with debt, am I going to be responsible for that debt? And the answer typically is no. You're not going to be responsible for the debt unless you co-signed for it. So if you co-signed on a student loan for your child, for example, and your child were to pass away, you would theoretically be responsible. Now, I am also going to talk about student loans here as an issue that causes my clients to file bankruptcy. But just know that for purposes of this part of the analysis, a lot of times people will file for bankruptcy because the other breadwinner has died. So my husband died and didn't leave me with very much life insurance, and so I don't have enough to pay all the bills. And so that might be a reason why the wife would want to file for bankruptcy. But again, in a scenario like that, the wife is only going to be responsible for her debts or joint debts. So if I were to pass away and had credit cards, and I do have credit cards in my name that I use to support the law firm, if I were to pass away, my wife would not be responsible for those debts that are in my name alone, because she is not a signer for those credit cards. So she would not be responsible for those debts. So the only people that are going to be responsible for debts in a death situation, a situation where one of the spouses has passed away, is going to be if it's a joint debt. More so, what I mean by the loss of a spouse is the loss of the spouse's income. So if a spouse passes away without having a life insurance policy, now you leave behind your wife, your kids, your husband, your kids, whatever the situation may be, but without your income. And so if this is a household with two working parents that relies on two working parents to make ends meet, and one of those spouses passes away, the other one might want to consider a bankruptcy to eliminate those joint debts or those debts in that spouse's name alone that are not covered by life insurance, that there is not enough life insurance to handle those debts, to handle that monthly nut that they need to make to pay all their bills. So loss of a spouse may be another reason why people want to file for bankruptcy. Another reason people want to file for bankruptcy is medical debt, medical bills. I have a lot of clients that have overwhelming medical bills. Now, regardless of what your political leanings are, regardless of what you believe, people are getting higher and higher medical bills. They're getting medical bills that are more and more expensive. And so great reason to look into supplemental insurance like AFLAC, greatly reason to look into lower premium plans, Affordable Care Act plans, and those types of things. But frankly, a lot of people are getting emergency surgeries. They're getting into situations where they need an ambulance, they need an ER, and for whatever reason, and then they cannot cover those bills. That is a reason that they may be filing bankruptcy. Now, medical bills are easy to negotiate. And I say easy tongue in cheek. I say easy with a grain of salt, because you do have to put forth some effort. You do have to actually engage with the medical billing company, but most medical billing companies will provide you with some type of payment plan that'll allow you to pay back your medical bills. So medical bills are a reason that people file for bankruptcy with me, but they're not one of the leading reasons. Typically, medical bills can be negotiated away, but if the medical bills are high enough, the ER visits, the ambulance visits. I had a client once that had to be airlifted, and the bill for the helicopter was just overwhelming, and she couldn't pay it. And so that was one reason that we had to file for bankruptcy. Related to medical debt is if you are involved in some kind of accident, you have a personal injury case, you have a personal injury lawsuit where you were hurt in a personal injury situation. Well, you may have a great personal injury case. You may have a personal injury case that the personal injury attorneys are salivating over. I've got a great one that I refer to, Jim and Kellyanne Jenkins. Jim has been on the show before in previous episodes, and I have other personal injury attorneys that I have relationships with that I can introduce you to. But while you're waiting for that fantastic settlement to come in, the creditors don't stop calling. And so a lot of times I have clients that are involved in a car accident or a slip and fall accident or something like that, and they can't pay their bills because they can't work because of the injury. And so that's another reason where bankruptcy may be an appropriate solution. Now, that's a situation where we have to be really, really careful, because in a bankruptcy situation, all assets of the debtor become property of the bankruptcy estate. And so theoretically, that personal injury lawsuit becomes an asset of the bankruptcy estate, and it's something that we have to account for within the bankruptcy. We have to account for the personal injury lawsuit as an asset within the bankruptcy. So the loss of income is more so why the clients file, not necessarily that they got into a car accident or a slip and fall accident or something like that. But that is one of the reasons that a lot of my clients file. I think the number one reason the clients file with my office is credit card debts or similar unsecured debts. Unsecured debts being a debt that is not secured by an asset, a credit card, a revolving line of credit, something like that. Now, along with credit card debts, a lot of my clients get into stuff that has been repossessed. So a car has been repossessed and there's a value of the loan that is greater than the value of the car, and the car creditor wants that additional money. And so along with the credit card debts, the unsecured debts, we also have a lot of repossession issues that cause my clients to file bankruptcy. But I think credit card debt is probably the number one reason, the inability to repay credit cards. And so, I mean, we've all heard the professional speakers around that talk about when you have credit card debt and what to do. And I may come out with more episodes about that as we get here the end of year 3 into year 4 of the podcast. But basically, if you have unsecured debt, the bankruptcy will eliminate unsecured debt. Now, I'm not going to get into chapter 7 versus chapter 13. I've done a couple of different episodes. I've got a couple of videos on the website. I've got multiple blogs on the website that all talk about the difference between chapter 7 and chapter 13, the difference between a liquidation and a reorganization or a payment plan bankruptcy. So I'm not going to get into the difference between 7s and 13s in this episode. You can go back and check out some of my previous episodes. But I will say that credit card debts are one of the reasons that people file for bankruptcy. And a lot of times people will say to me, you know, I'll say, how much do you have in credit card debt? And I can tell that they're embarrassed to tell me. And some of them will say, I've got 10,000, and they'll be really ashamed by 10,000 or 20,000. They'll be really ashamed by 20,000 in debt. I have other people that have 70, 80, $90,000 in debt, and they don't bat an eye at it. It's just debt. I have one client right now where we're trying to eliminate millions, tens of millions of dollars of debt. And so, you know, I've said many, many times on the podcast, in the blog, on the videos, I've said many times that a lot of times all you have to do is have more debt than you can afford to repay. So if you've got $10,000 in debt and you make $40,000 in a year in income, that's 25% of your income is going to having to pay that debt. That may be a situation where bankruptcy may be an attractive option. If you've got $10,000 in debt and you make $200,000 a year, then I'm probably going to advise you not to file a bankruptcy and to simply pay it off. If you have $100,000 in debt and you make $150,000 a year, again, maybe there you may be a good candidate for a bankruptcy, because the bankruptcy is what 2/3 of what you earn in income. And so that may be another situation where you want to file the bankruptcy to eliminate the unsecured debt. So I don't necessarily think that the amount of unsecured debt is relevant. I think what's relevant is that you cannot afford to pay it back over a short period of time. That might be a reason to file for bankruptcy. Another reason that my clients file for bankruptcy is because of IRS debt. Massive, massive IRS debt. Now, again, massive IRS debt may mean 10,000 to the one that makes 30,000 a year. It may mean 100,000 to the one that makes $125,000 a year. But again, IRS debt. Now, for the most part, IRS debt is non-dischargeable, meaning the bankruptcy will not eliminate the IRS debt. In a situation like that, maybe we look at a Chapter 13, maybe we look at a payment plan bankruptcy, and we repay that IRS debt over time. There are situations where the IRS would be dischargeable. And so either I can help you with that determination, or I've got a couple of different attorneys that I refer to that can help you make that determination as to whether the IRS would be dischargeable or not. They can even maybe file your bankruptcy for you. And so they may be a better fit for you than I would be. But again, IRS debt is another one of those major reasons that people file for bankruptcy. A lot of times the attorneys that I refer to will do the analysis and say, yes, this debt is dischargeable, go ahead and file bankruptcy. Or they'll say this debt is not dischargeable, let's go ahead and let's go ahead and negotiate with the IRS to pay off the IRS debt. Other times, people may say, well, we know the IRS debt is non-dischargeable, but we still want to file bankruptcy to get rid of the other stuff. So if I'm making a minimum $500, $600, $700, $800 in credit card payments, minimum payments, but I can file the bankruptcy and I can get rid of that, I can divert that money to faster paying off the IRS. And that way, even though the bankruptcy wouldn't address the IRS, the bankruptcy would address the other debts that would help me pay down the IRS even faster. So that's another reason that people may file for bankruptcy. Another reason that people come to me to file bankruptcy is because they close their business. They have a business that is not performing, or they have to close the business or something like that. That's a situation where they may need to file bankruptcy, because when they close their business, they don't have any other means to make money. And so they need to close their business. They need to file bankruptcy to eliminate their debt. Now, what that does is it brings up situations of, well, who is filing or what is filing? Is the individual owner filing bankruptcy because they closed their business so they're not getting the income? Or is the business entity itself filing bankruptcy, or both? Do we want to do both? Now, there are some quirks when a business files bankruptcy, but for the most part, the business would file bankruptcy. And then a lot of times what I'll do is I'll look at, has the individual owner guaranteed the debts of the business? So if the business files bankruptcy, but the owner has guaranteed the debts of the business, then all the creditors are going to do is divert from the business to the owner to say, hey, you filed the guarantees, we want to collect from you. In a situation like that, where the owner has simply shut down his business, maybe we don't file for the business at all. We file for the owner to eliminate the guarantees, and then we let the creditors come and pick at the bones of a dead business. But loss of business, close of business, all of those are different types of issues that might require my clients to file bankruptcy. Foreclosure. I can't ignore foreclosure. When I first started my practice, foreclosure was probably the number one reason that people filed for bankruptcy. And we would either use a Chapter 13 to try to catch up the mortgage arrears, or we would use a Chapter 7 to eliminate the bankruptcy, to eliminate the mortgage debt and get rid of the house altogether. And I've done a ton of podcasts. I've done a ton of blogs. I've done a ton of information out there about foreclosure and bankruptcy and the intersection of those two things. These days, we have mortgage modifications and a mortgage modification mediation process within a Chapter 13, where we can try to modify the loan and save the house within the Chapter 13. And again, I've done a ton of podcast episodes, a ton of blog entries, a ton of videos about the intersection of foreclosure and bankruptcy and mortgage modification mediation. In fact, just to divert for a second, I have a client who is trying to modify her loan within a Chapter 13 case, and we got a letter back from the from the mortgage company that said, we are declining your request for a loan modification because whatever garbage, bogus reason, they declined the mortgage modification. But then they said, do you still want to have a mediation to discuss it? And my thought was, why would we have a mediation to discuss why you said no to the loan modification? The mediation is not going to convince you to give my client the loan modification. You're not going in there with an open mind to try to resolve this situation. All you're going to do is tell us why the loan modification was denied, which you've already told us. That then led me down the path to say, why isn't that bad faith? A couple of episodes ago, I went on a rant. A couple of podcast episodes ago, I went on a rant about the mortgage modification process in Florida, both in state court and in federal court, and how the system is flawed and how mortgage modifications are bogus. And this example just feeds into that analogy. You've got a bank that says your mortgage modification is denied, but let's have a mediation to discuss it. Well, yeah, because what I'd love to do is go down to the office there and mediate and waste more of my time for you to tell me why you've already denied it, which you've already told me. So I'm trying to determine if this is a way that I can hold the banks liable for a bad faith mediation. So maybe I'll keep you posted on that. Maybe that'll be another episode, but definitely mortgage foreclosures are a big reason why my clients need to file bankruptcy. And again, we can use the bankruptcy to either save the house, or we can use the bankruptcy to get rid of the debt and then get rid of the house on top of that. And there's a couple of quirks there. Again, go back and listen to some of my previous podcast episodes where I talk about the surrender of the house and some of that other stuff, and that'll give you some more information there. Or give us a call, and I'm glad to talk to you about the intersection of foreclosure law and bankruptcy law. I think the last thing that I'm going to talk about here is that a lot of my clients may want to file bankruptcy because of student loans, and I've done a lot of research on the issue of student loans. And I will say that there are other attorneys and other organizations out there that know a ton, and a ton more than I do, about student loans. But I don't think I'm necessarily a slouch in the area. In fact, I've had a couple of guests on my show about student loans and how to get rid of student loans, both within bankruptcy and outside of a bankruptcy. But again, some of the strategies that we have with student loans are very similar to the IRS. Now, interestingly, the student loan is not dischargeable, but what the bankruptcy code says is that it's an unsecured debt, so it needs to be treated like other unsecured debts. So if we have a payment plan bankruptcy, a Chapter 13 bankruptcy, where we're paying back our loans at 20% of what's owed, we're paying back our creditors at 20% of what's owed, and you have $50,000 in student loan debt. Well, what that means is through the bankruptcy, your student loans are going to get 10 grand. When the bankruptcy is over, you're still going to owe the remaining 40 grand to the student loan companies. So the student loans are not dischargeable, but they are treated the same as other unsecured creditors in a bankruptcy. However, there have been a ton of developments in the student loan area. We have income-driven repayment plans. We have consolidation loans. We have other types of repayment plans on student loans. There is an area where we can discharge a student loan if we can prove that it was not for an educational benefit. There are situations where we can threaten to discharge student loans and call the bluff of the student loan company. There's all of these different student loans that are geared towards some of the more technical schools that are not accredited, some of the Caribbean schools that are not accredited. And so it wasn't for an educational benefit because you can't use your student loan to get a job. And so in some of those cases, student loans can be dischargeable. There may be the opportunity to get a hardship discharge of a student loan. Now, it is very, very difficult. There's a couple of different tests. And again, I've done podcasts, I've done blogs, all on the different types of tests. Here in Tampa, we use the Bruner test, which basically we have to prove that the debtor, the person in bankruptcy, will never, ever, ever in their life be able to earn enough money to even come close to paying off the student loan. A lot of times our bankruptcy judges like to see that they've cut other expenses, like they've cut cable, they don't go out to dinner, those types of things. Maybe they take public transportation instead of driving a car and paying for maintenance and paying for gas. Our judges like to see some of those other factors. But the bottom line is that we can use bankruptcy to get rid of student loans, or similar to the analogy of what I said with an IRS debt. If we can get rid of other debt that'll free up income that can then be used to pay the student loans, the bankruptcy won't get rid of the student loans, but the bankruptcy will get rid of other debts that can be used to then funnel to the student loans to pay off the student loans. So I think those are the main reasons why many of my clients tend to file for bankruptcy. If any more come up, I will do a follow-up episode and I will keep you posted. But, a lot of times people file for bankruptcy because they're in a divorce, because they've lost a spouse or lost a source of income. They've lost their job. They had medical issues, or they had personal injury issues, or injuries that stopped them from working. They've had credit card debts, repossessions, other types of things like that. They've had the IRS chasing them. They've had to close their business. They've had to deal with a foreclosure, or they have student loans that are crushing them. All of these are reasons why people may want to file for bankruptcy or may need to file for bankruptcy. Again, another plug for my book on Amazon. A lot of these things are chapters in the Crushing Debt book. I know foreclosures are, student loans are, IRS, credit card debts. A lot of those topics are chapters in the book or are discussed in the book. You can find it on Amazon. Just type my name, Sean Yesner, or type the Crushing Debt book. That's the reason that a lot of my clients tend to file for bankruptcy. If any of these apply to you, please reach out. It's a confidential free hour-long consultation. I'll talk to you about all these topics. Now, with the one caveat that if you're outside of Florida, I may need to refer you to an attorney that's in your state. But if you happen to be in Florida, please give me a call. We can talk about all of these different issues. If you're outside of Florida, also give me a call. I will connect you. I will find an attorney that can talk to you in whatever state where you live about whether bankruptcy is the right alternative for you. But I think that is it for this week's episode. If you have something you want to talk about, you want me to talk about in a future episode, let me know. Otherwise, we will catch you in next week's episode of the Crushing Debt podcast. Okay, so Facebook Live, we are done. So let's see. I had to I had to navigate away from Facebook Live. So let's see. Mom. Hi, Mom. Let's see if you're still, I don't know if you're still watching or not, but hi, Mom. Michael Watkins, is that offer in compromise? So I assume when I was talking about the IRS, you were asking me, was I talking about an offer in compromise? Yes, an offer in compromise is a great strategy to eliminate IRS debt. It's a way to negotiate with the IRS and eliminate the IRS debt. An offer in compromise is not necessarily a good strategy when you're talking about bankruptcy, because bankruptcy is eliminating the debt, or like I said in the episode, eliminating the other debt so that you can spend more towards the IRS. But the offer in compromise is a great way to get rid of IRS debt outside of a bankruptcy. And it would be one strategy that I would recommend to see if bankruptcy might not be an option. Then definitely an offer in compromise is. So other than that, I am going to go ahead and save this episode that I recorded. And you know what? I forgot to mention that I'm going to probably release this episode next Thursday before my birthday. So you all will know that as you look at this. And then the last episode that I recorded, I also did a behind the scenes, and I turned it into a YouTube video and posted it on YouTube. So, you know, again, after this episode goes live, I will also turn it into a YouTube video and post that on YouTube. Yeah, Michael, everything's going well. Thank you. I appreciate it. Everything is going great. I hope everything's going good for you too. A couple of announcements. I did hire an associate attorney. Her name is Tiffany. So I will hope to get her on the podcast here soon. And she and I can do some joint podcasts and create some additional material for all of you. But Yesner Law is growing. I do have an associate attorney now who has started here at the firm. Actually, she takes the bar in February, but we're confident she's going to pass. So that is it for this one. What I'm going to do is stop this video, let my recording software capture the episode that I just recorded, maybe take a little bit of a potty break, and then I will come back, get back onto Facebook Live, record another episode, I think, depending on how much time I have here. And I appreciate you all tuning in, and tune in again in a few minutes and look for this video to come out in the next week or so on YouTube. And that's all Facebook. I'll see you here in a few minutes.